we can get the railroad moved that is well within 300 feet of the middle school?
I sent an email.
That is a concern.
Yeah.
It's a huge concern.
And there's an opening in that fence. Last time I was up there for soccer one night, that fence behind the school, there was an opening, like a big opening, right through the tracks. I suspect the kids are playing, the ball goes over. I asked the board a week or so ago to authorize me to research some of those issues as it relates to the train. I didn't want to do that on my own. In terms of the noise is what I get inundated with, and I've sent some of those emails and calls along to the board because of anybody that's been woken up between midnight and 5 a.m. from the train whistle knows that's a constant, and unfortunately that doesn't seem like it's going away. I mean, it's going to be there forever. So I asked the board, and the board can authorize me to research that, to research rerouting the train around the school if that's even possible. Well, in the past, the board, rightfully so, needs to curtail my exploits as to what I find interesting. So I didn't do anything until the board says go ahead and do it. So if you want me, I don't really need to vote. You can just, if your board wants me to do it.
It's a good idea to check into this.
That would be wonderful.
Do you agree? Elizabeth? Do you agree with letting them look into that? Frank, what's your opinion?
On whether there's a cap on it or it's free reign.
No, I'll keep it within. I'll do some initial research and see if there's anything there. And then I'll come back to the board and you can decide if we need to go any further.
Check out those subjects we just talked
About the noise?
And about if you can possibly reroute.
Because it literally runs 7,500 feet right behind there.
Well,
Right on.
yeah, it's very close, and I've been up doing soccer and I've seen it go by. And maybe not as important, but very important is the noise.
No, it's the fumes. If there were an explosion there, the whole school would be gone.
Oh, absolutely. We had an incident in the township where that garbage truck hit the underpass, and luckily the conductor for that train stopped short, or that could have fallen off, not too far up the road.
There's a big trestle right there. You're right.
Yep.
I'll conclude then. I just want to finish just by saying that, like, the last thing that Pam Judy said was that, she asked the council that she approached to take every precaution to protect the residents of the community, that it's your duty as elected officials to ensure their welfare and safety. And that's a charge that no one should be taking lightly.
Thank you.
Thank you.
Crystal Burt, 1040 Indian. My name is Crystal Burt, and I have been a resident of Cecil Township for 18 years, growing up in the area and then deciding to start a family here. I'm currently a resident of Temple Run, which, as you all know, is less than a mile away from the proposed compressor station. Cecil Township was recently voted #1 city in PA to raise a family based on crime rates in parks, etc. And lately, however, Holland has been in the news for gas drilling issues focusing on various health concerns. The proposed gas compressor station would only add to the growing number of issues with the numerous carcinogens that are used at these stations, such as benzene, toluene, and formaldehyde. As a chemist by day, I know the numerous health concerns that come with these chemicals, along with many other ones, which is why extreme precautions are taken when working with these chemicals in the industrial lab, from special gloves to respirators to sometimes being completely enclosed. The thought of these chemicals in my backyard where my child plays and we eat dinner is sickening. I have read and heard so many heartbreaking stories of people's health deteriorating after these companies have come in and installed compressor stations or drill inappropriately. For example, Melanie just spoke about Pam Judy, so I'm not going to go into a lot of detail about her letter. I do want to emphasize that she even had to go for blood and urine analysis after learning about all the chemicals being present in her air to find out that her body contained measurable levels of benzene and phenol. I don't know about you, but I really don't want to come home from work and worry about what chemicals I'm breathing in, what tests do I have to go take, what my 2-year-old daughter has to go to the doctors and I have to report that she's been exposed to. I bring up this example to show you how your life can change so drastically like Pam Judy, and a simple task of just letting your kids play outside can become something of the past, along with constantly having to worry about what chemicals are now in your body adversely affecting it. These health concerns are only one of the many issues that accompany compressor stations. Any type of malfunction or leak could lead to an explosion or fire that could take out the nearby neighborhoods along with the Cecil Intermediate School, since it is within the fallout area. Overall, the numerous risks associated with the proposed compressor station clearly show how negatively this can impact the community. I ask you, the Cecil Township Board of Supervisors, to take every precaution to protect the residents of this community, since it is your duty as elected officials to ensure the welfare and safety. The safety of the residents who live near the proposed station, along with the hundreds of students who attend the Cecil Intermediate School daily, that is only 1,500 feet from the backside of the station, needs to be the top priority of this board. I have heard people state that we should stop fighting the gas industry and move forward since we have already missed out on money opportunities. But I would like to remember and remind them that no amount of money can buy back your health or your life for that matter. The money will eventually run out and cannot buy you the happiness of good health. Please consider all of these points when making this important decision tonight, and remember that your #1 priority is to keep the residents of Cecil Township safe. Thank you.
My name is Kathy Helbling. My address is 125 Woodhaven Drive. I am here in regards to the proposed compressor station. My actual question is actually for Elizabeth. In going through my paperwork from the original application from 2011, I found a petition that was signed by you and your husband to keep the compressor out of that location. Obviously, at that time, you had to have felt strong enough that that location was not right and you signed the petition. So my question to you is, what has changed?
If I signed it, and I don't remember doing it, and I really don't know what my husband has done, if we signed it, and you might be right, I originally felt that I did sign it, you're absolutely right. I originally felt that the compressor station, in fact, Kathy, if I'm not mistaken, I talked to you about it early on and gave you some thoughts on it. Do you remember that?
We've had many conversations over all of the years in the meetings.
I think that we only had one in private that I spoke to you about it. And I also spoke against it as well at the public hearings. And I did it for a reason. I felt that the compressor station would be built in Cecil Township, that it had to be and should be. However, I felt that there should be conditions imposed upon the company coming in, and that was the basis of my signing it, and that was the basis of my objections when I testified at the hearing.
Just to clarify for people who cannot see it, I just want to say that the summary says, we the undersigned are concerned citizens of Cecil Township who oppose the special exception request by Mark West Liberty Midstream and Resource for the installation of a natural gas compressor station situated on Route 9 Beatty, approximately a half-mile north of Coleman Road. It has the partial ID number in the I-1 Light Industrial Zoning District. So just for those who cannot see it, I wanted to clarify.
Right, absolutely. And anyone who's discussed it with me, I've told them the same thing that I just said to you right now.
That you signed it, okay.
Not that I signed that, but that I objected to it in an effort to give those who dissented ammunition. I fully expected the zoning hearing board to approve it, and I wanted them to approve it with conditions. And that was the purpose of my discussion with you, and that's why I signed it, and that's why I spoke. And my position has not changed.
I thank the board.
I believe that the compressor station is vital to our township, to our economy, and to our future. If we cannot get a compressor station, we cannot move the gas. If we don't move the gas, nobody will drill in the area. And if nobody drills in the area, we're going to end up without the electric that you have here tonight, because I don't find them very humorous. I think it's a very serious situation. The gas companies are now supplying the power company, and because it's less expensive, and if you would read, you would understand and know that that's a fact. I've said that.
Thank you for your opinion. I thank the board tonight. You guys have been more than gracious listening to everybody for way too long for comments, and obviously there's a lot of people here and with time constraints. I just know that everybody's not going to get their chance to be heard. So I just want to say with the audience, if there's anyone in here who thinks that the board should appeal this decision, to please raise your hand for the board. Thank you for your time.
Elizabeth raised a point I wanted to address something because I know I jump on a term about the conditions. Because one of my issues that I thought if we were unsuccessful, that it would come back down and be remanded to the zoning hearing board for the board to take further action as it relates to the conditions. The court skipped a couple things in the process. Typically what the court's done, and even the court in this case, cited an opinion where this matter must be remanded to the zoning hearing board with the direction that such special exception apply for be granted upon such terms and conditions as the board may deem appropriate. Normally that would be the case. The language that the court used was a little bit different. It said, should the board determine within this 45-day period and within the confines of the UDO's objective standards and criteria that any terms or conditions are needed to attach to the special exception application in order to ensure compliance with the UDO, it shall specify the applicable UDO provision and explain why the term or condition is necessary. Now, the board that knows zoning understands that the conditions don't come from compliance with the ordinance. The conditions come from the hearing and the evidence that is introduced at the hearing. The court has limited the zoning hearing board to putting conditions on that show compliance with the UDO. And the UDO, you cannot approve a special exception or a conditional use. You cannot make it a condition that you comply with the law. You can't say, okay, we will approve you so long as you meet that standard in the conditional use. You can't condition compliance on the stated condition. And that's essentially what I read the court doing. The court doesn't go back and say, like I just read to you, they go back and with further proceedings consistent with our opinion, meaning that they've met their burden, and now let's look to the condition phase. The condition phase being driven by the evidence that was received. The township back in the day, to the zoning hearing board, we weren't sure if we were going to be successful. I'm looking to see if I have it here. But the board indicated that if we're not successful, we want you to consider these 30 or 40 or 50 conditions, one of them being electric compressors. And so there was a whole list, to Elizabeth's point, of she may not have been against it as long as they would have conditioned. None of those conditions are before the zoning hearing board now. And that ability to condition approval, to add those things that were brought up at the meeting, seemingly the court didn't give us that opportunity. And also, normally what would happen, and Tom, you would know this, that once they meet their initial burden, the burden switches to the objectors. And the objectors would have to come in and show that they've satisfied, or that it would be detrimental to the public health, safety, and welfare. Well, they didn't remand, because if you didn't meet the threshold burden of meeting the condition, which our zoning hearing board said they never did, they never got to the objectors. And the Commonwealth Court said, well, we're going to look and say, oh, the objectors would have never met their burden. But the case law is very clear that it's the zoning hearing board who has to establish the weight of the evidence and the credibility of the objectors, and then make a decision whether the objectors met their burden. The Commonwealth Court eliminated the objectors' ability to be heard by the zoning hearing board. So two of my procedural issues that I have with that is just that the zoning hearing board will not be given the opportunity to condition approval based on the record, not on the Unified Development Ordinance, but based on the record that was there. As the board knows, in a conditional use, we may just add things and say, we'll approve this subject to you doing X, Y, and Z. They're not additional ordinance factors. Those are things that come up at the hearing supported by the evidence. And if you look at the opinion, the court does not direct that. The court directs compliance with conditions that would be part of the ordinance. And we don't condition compliance with the ordinance. You either comply with it or you don't. So that's to your point, Elizabeth, there was a lot of information.
There certainly was, but there are 5 people here that
I'm sorry,
were
that's
writing
okay.
too.
I'm sorry.